Morning. This is the point in breakfast presentations that I usually start thinking of my to-do list at the office. And Tim is here, so he's definitely thinking about what he's going to do at the office. I'll go over the new changes to the Voluntary Disclosure Program and get out of your way so all of you can get back to the good stuff at your offices. So I'm sure that all of you have heard that there is major changes coming to the Voluntary Disclosure Program effective March 1st, 2018. And the highlights of the changes include the introduction of 2 separate tracks, new application requirements, what I call a new voluntary definition, and a reduction to the relief granted to some taxpayers, depending on what track they're on, as well as what's starting to concern me more and more is restrictions on the ability of taxpayers to object. So, as I said, we're moving into a universe in which the Voluntary Disclosure Program has 2 separate tracks. The first one being the general program, and the second one, where all the excitement is going to lie, is going to be in the limited program. So before we get into the 2 separate tracks, we'll look at what changes are going to apply to all of the voluntary disclosures, so whether you're in the general track or the limited track. And I'd be remiss if I didn't mention, so as I said, these changes come into effect on March 1st, and so what that means is if taxpayers want to take advantage of the existing program and sort of avoid being characterized in one of these tracks, then what needs to happen is applications need to be filed and information needs to be released, including taxpayers' names, before February 28th, 2017. So, 2018, excuse me. So the race is on as we're starting to see any lingering voluntary disclosures or taxpayers who are thinking about coming forward but kind of hesitating, coming forward now and taking that step to get under the existing program. So, generally speaking, what are the changes that we're looking at, or what we all should expect? The no-name application and process is eliminated. Secondly, there's a statement in the new information circular that says that the applicant should generally, it says, identify the advisor that assisted in respect to the subject matter of the voluntary disclosure application, which is going to be interesting. CRA will adopt the position that an application does not meet the voluntary disclosure condition, so it doesn't meet the voluntary condition if the CRA has received information related to the specific taxpayer or related taxpayers' potential involvement in noncompliance. And again, like many of these things that I'm going to discuss today, the information that we currently have is in the CRA press release as well as the information circular. And so we don't have a lot of guidance about how these are going to play out on a day-to-day basis or as these voluntary disclosures are filed. And then fourth, interestingly, CRA reserves the right to audit the taxation years that include a misrepresentation, which really isn't a real change. That's always been open to the CRA to do, but what is the real change is the statement that the CRA may withdraw voluntary disclosure relief at a later date. And again, we don't have a lot of guidance in the information circular in terms of how this is going to happen or the circumstances in which this would happen on a practical basis. And so it's going to be, I think, for all of us, as we take clients through the program, a learning process. Our firm has requested CRA's internal guidelines for the new voluntary disclosure program through the Access to Information and Privacy Directorate. We don't have that yet. We believe that should shed a little bit more light on how the CRA is being directed internally. But again, I think that us in private practice as well as the CRA is going to be learning how these changes are going to affect all of us and how CRA is going to treat it as we walk clients through the program. So starting with the no-name application and the process being eliminated, this is significant. Our firm, as most law firms and accounting firms, have used this no-name process more to, I think, get taxpayers comfortable with going through the voluntary disclosure process, but also for an opportunity to engage the CRA, clarify some facts, and kind of set out the lay of the land with the CRA. The nice thing about the no-name process was the opportunity to have those conversations with CRA in an environment in which both parties didn't have to worry about enforcement action, some sort of enforcement action, taking out the voluntariness of the voluntary disclosure. I think it's unfortunate that that aspect has been changed and eliminated. But what the CRA has said in the information circular is that they will provide they will engage in pre-disclosure discussions. And so they'll essentially, what the CRA is saying is, without the protection of the no-name process, they will engage with taxpayers and lawyers and accountants to get a better understanding of how the CRA may treat it. But again, CRA emphasizes, as they do in most of these things, that these conversations are not binding on the CRA and for the benefit of the taxpayer. The second change that I talked about was the idea that taxpayers should generally identify the advisor if they had some involvement in the subject matter of the voluntary disclosure. This is a bit of a drawback from what was in the draft proposals, where in the draft proposals there was a requirement to identify that advisor. CRA pulls back a bit. Now, what's interesting when you read the information circular closely is in paragraph 44, as I was saying, the CRA has that pullback. They say the taxpayer should generally, which seems to make it optional. And then in the paragraph right underneath it, which is paragraph 45, the CRA goes into the notion that taxpayers are required to disclose all information to the CRA that's demanded to ensure that the voluntary disclosure is complete, so to meet the completeness condition. Listed in that paragraph is the advisor's name and identity. And so we have this circumstance in the two paragraphs where you see in one instance the CRA is pulled back from the draft and said, this is kind of a general thing that the taxpayer should do. And secondly, then you have in the paragraph that immediately follows this idea that, well, if it's requested, the CRA might push, and on the basis of a threat that if this information about who the advisor is and I guess what the involvement is isn't disclosed, then that could violate the complete condition and throw the voluntary disclosure offside. So again, it's going to be really interesting to see how that plays out and circumstances in which the CRA requests the identification of the advisor who was involved and the extent to which they push for that. I'm not sure. I look at it and I think I understand the logic behind the CRA wanting to know who the advisor is. I don't know whether pushing for that or having those conditions in are in the CRA's interests at large. And the reason why I say that is this. If the voluntary disclosure program is designed to encourage taxpayers to come forward with noncompliance, and I know many people in this room, and if our job is to help the taxpayers walk through that noncompliance and reveal that noncompliance in a really safe way, I wonder whether adding a requirement that taxpayers need to disclose who their advisors are would lead more practitioners to encourage taxpayers to reveal that noncompliance under the voluntary disclosure program, or if it's possible that in some circumstances that would have the opposite effect. So we could have a circumstance in which there's a conflict essentially between an advisor who may in other circumstances recommend that a taxpayer engages in the voluntary disclosure program to correct the noncompliance. But if there's some risk to that advisor, human nature is what it is, I wonder whether advisors would be so quick to encourage their clients to come forward to correct that noncompliance. Next, in regards to general changes, what I think essentially expands the definition of the voluntary condition, and that's this idea that if the CRA has received information regarding the specific taxpayer, so essentially the change expands it, because if it receives it, then we're talking about then that would violate the voluntary condition. So we hear recently there was PayPal in the news and the CRA request for information under PayPal. That would likely form part of this. But again, we don't have a definition and we don't have any examples in terms of what received means, and so that definition could be broadly expanded for voluntary disclosure purposes. And again, this is what we've seen. This deviates from what we've seen under the existing program. Under the existing program, CRA has used the voluntary disclosure program, frankly, I think rightly, to gently encourage or to provide an environment that is safe for taxpayers to come forward. And I think what we're seeing here is we're starting to see the CRA deviate from that kind of approach. And so it's likely that those changes will have an impact moving forward. And again, as I said, the CRA has that ability to audit other taxation years, which isn't a change from the past, really, or expand it throughout taxation years. But that idea that the CRA would withdraw the voluntary disclosure relief at some later date is interesting and certainly will be controversial if and when CRA takes that approach. Another important thing that's generally going to apply to the new voluntary disclosure program is the requirement for taxpayers to pay the estimated tax in the voluntary disclosure. So what CRA is saying is this is essentially a fifth condition to the voluntary disclosure program, and that will be one of the requirements for acceptance under the voluntary disclosure program. I go back and forth about whether this is actually impactful or not. In my experience, most taxpayers that do come forward under the voluntary disclosure program have the desire to get back on the side of right. I don't think anybody's going to like this. Nobody likes cutting the check. But I think the fact of the matter is that although there was a lot of voices decrying that this isn't fair or this shouldn't be part of it, I don't think that this is going to make as significant change to the voluntary disclosure program as others might think. What's interesting about it, though, is in how the CRA is actually going to implement this. And so in circumstances in which a taxpayer can't pay, what are we going to see from a collections perspective? So there's this notion under the new voluntary disclosure program that if taxpayers can't pay the estimated tax, then they can enter into a payment arrangement with the CRA. And for those of us in the room who've attempted to negotiate a payment arrangement with the CRA, it's always a interesting occurrence. And it's going to be interesting to see whether the CRA is going to apply the normal kind of collection framework that they usually apply in other instances to the new voluntary disclosure program. So CRA is saying that they are going to require full financial disclosure, but who is going to be making this decision in terms of what constitutes an acceptable payment arrangement? When in the process does that happen? So you could see a circumstance in which the voluntary disclosure officer is approving or at least accepting payment arrangements, or if we're going to have another party involved, sort of a independent separate party, a CRA collection officer, to go through that process, to get involved in the process and then go through that process with the taxpayer, which, again, the more people, in our experience, the more people that get involved in this type of thing, I think the more uncertainty is. And when we're talking about a condition that has the prospect of disqualifying a voluntary disclosure, things get serious pretty quickly. So, as I said, the new voluntary disclosure program is split into the general program and the limited program. And so, essentially, the general program relates to minor noncompliance, and in these cases, CRA will cancel penalties, a portion of the accrued interest in the years preceding the three most taxation years. So in the past, we saw a reduction of 4% in these years, and now that's been changed to 50% of the applicable interest rate. So the limited program is likely to be where the interest lies and where the fireworks are going to start. CRA will push or characterize voluntary disclosures under the limited program if the CRA believes that, and again, I'm just going to say that again, if the CRA believes that there is an element of intentional conduct. And so in these circumstances, the CRA would, the relief that's gained is that the CRA will not refer the matter for criminal prosecution. However, it will not cancel interest. It also won't impose gross negligence penalties, but they will impose other applicable penalties. So we're talking about late filing penalties and repeat late filing penalties. And again, going through the theme of kind of this presentation, there's a high level of subjectivity involved in this. And so the CRA says we'll make this determination in terms of what program the voluntary disclosure should apply to on a case-by-case basis. So what are the factors that the CRA is going to look at to determine whether something should be characterized in the limited program as opposed to the general program? And we look at these 5. So did the applicant use offshore entities or undertake efforts to actively avoid detection? Does noncompliance involve large dollar amounts? Does it relate to multiple years? Is the taxpayer sophisticated? And was the application filed following a official CRA statement that intended to focus on the noncompliance? Other factors that are going to influence whether the CRA characterizes a disclosure as a limited disclosure is whether a corporation has gross revenue in excess of $250 million in 2 of their last 5 taxation years, as well as any related entities. And if that's the case, then it's likely, although not certain, that the CRA will characterize the voluntary disclosure under the limited program. Also, if the CRA maintains the position that if the taxpayer receives a letter, so we've seen, I'm sure most of you have seen some of these pre-audit letters or letters that encourage taxpayers to review their records to ensure that there's no non-compliance. Those type of letters will not disqualify a voluntary disclosure, but if those types of letters exist, the CRA will take that as a factor and could characterize the voluntary disclosures that have those facts in them as part of the limited program. So when we look at these, we start to get concerned about, again, that level of subjectivity and the possible arbitrariness of decisions that we could see forward from the CRA coming out of voluntary disclosures. So what does it mean to actively avoid detection? Who's going to make this determination and on what basis? Simply, what constitutes large dollar amounts? Is this a set amount or is it a judgment based on the taxpayer's other income? And we've seen this in other disputes and areas. It's not defined, and there is a high degree of subjectivity depending on who the CRA official you get will likely impact whether they perceive this to be a high dollar amount or not. Again, multiple taxation years. Does that mean more than a few? Most voluntary disclosures that we handle include more than 3 years, and so that's a pretty low bar to have a factor being to characterize a voluntary disclosure under the limited program. And again, multiple years isn't defined anywhere in the information circular, and there's no example given for it. Determining the taxpayer's level of sophistication, always difficult, always an interesting exercise in and of itself. And then finally, the question remains outstanding: on what type of statement is the CRA talking about? What will rise to the level of an official public statement? And why isn't there any guidelines for us to have a better idea of what type of information would the CRA release that would cause the CRA to believe that a taxpayer should be, or a taxpayer's disclosure should be characterized under the limited program? I mentioned in the first slide the idea of the restricted objection rights. And so under the new VDP, there's those restrictions on the ability to object. So what the CRA is saying is that they require a taxpayer to waive their objection rights as a precondition to the acceptance of the voluntary disclosure. And when I first read that, I had to let that sit a bit with me, because the idea that taxpayers may be in a position to withdraw a voluntary disclosure to preserve objection rights seems to almost be untenable. It will put taxpayers in certain circumstances in a very difficult position and have to make a really tough choice. So now this doesn't mean all objection rights. So the taxpayers wouldn't be required to waive objection rights on things like calculation issues. So if the voluntary disclosure goes through, we see the reassessments on the back end, there's an error, then apparently the waiver won't apply to those types of disputes. as well as characterization issues aren't part of this as well. So capital income distinctions and things of that nature. But in thinking about simple examples of what types of disputes would fall in this category, the one that came to mind to me last night was repeat late filing penalties. So in a circumstance in which CRA takes the position that there was a late return, a set demand to file the return in the taxation year, and there was a late filing penalty assessed in one of the last 3 taxation years, that would be a circumstance in which the taxpayer wouldn't have the ability to object and would have to waive that as a precondition to the voluntary disclosure going through. Now, admittedly, there's a narrow case in which that's likely to occur, but just off the top, that may put the taxpayer in a position where it has that conflict. And for those of us who've dealt with repeat late filing penalties before, the upper limit of a late filing penalty is 50%. And so in a circumstance in which you're forced to accept a 50% penalty when there's some debate about whether it's late filed and the CRA has a burden of proof, it might, like I said, it might put taxpayers in a pretty interesting dilemma. So thinking about the anticipated impact of all this, I should have had a question mark beside fewer VDP applications, because I've gone back and forth on whether this is going to actually result in fewer VDP applications. It's going to be tough. I think it's going to be tough for taxpayers to come forward with the level of uncertainty, and as you'll see in my later points, this is going to play out over the course of many, many voluntary disclosures, all of us gaining experience in working with the CRA, but most likely the involvement of the federal court in terms of how the CRA is applying the program and how the program, or how the conditions in the program should be applied, and whether the decisions are reasonable or not. So there's I think one argument, and a lot of people have argued that this will cause fewer voluntary disclosure applications to come forward. I find that a little difficult to believe. Based on the level of information that the CRA has access to and is continuing to gain access to. I think that taxpayers as well as practitioners know that although this voluntary disclosure program isn't as beneficial or as favorable and is fraught with a level of uncertainty that we haven't had under the existing program, the reality is that not many taxpayers are willing to keep the risk of having that noncompliance and waiting to see if the CRA uncovers that noncompliance. Like I referred to, I think that we're going to see a lot more challenges to voluntary disclosures as we move forward. In particular, we're going to see more and more challenges for accepted disclosures. So disclosures in which the CRA has accepted the disclosure on the basis that it ought to be characterized under that limited program. And I think we're going to see more and more federal court matters and judicial review matters related to under what program ought the voluntary disclosure be accepted. And as I was saying, I think that the federal court is probably going to play a large part in determining what the proper application of these conditions are and what constitutes a reasonable decision under the new voluntary disclosure program. The difficulty with that is likely to span a few years before those decisions start to come down. And so we're all going to be living in a universe of uncertainty as we move through this program for likely the next few years. So those are my high-level comments on the new voluntary disclosure program. If anyone has any questions, I'd be happy to take them later. Thank you.